That little goddess.
Senator Clarkson.
Thank you.
Hello.
Hi.
Just going live, Senator.
I can tell you the floor action was scintillating.
I'm sure it was. And there is action going on at 2:20, but or 1:20, but I don't think we'll be up there. At 1:20, there's a presentation on the floor
USS Vermont.
for the submarine.
Oh, that's why Andy Perchlock was going up. He said, I'm going up for the USS
Yeah,
presentation. I said, I don't know what the hell you're talking about.
yeah.
Okay, well, here we are.
Okay, so we just went live.
Oh, thank you.
So-
I'm sorry.
Thank you. This is Senate Government Operations. It is Wednesday, March 16th. And we're going to be we're going to do a walkthrough of the two Burlington charters. And then we'll hear from any, I know that some House members have been invited either as sponsors or reporters. And we'll hear from them if they come. I also know that they are on the floor right now doing redistricting. That's my little bag of pills.
They're very colorful. They almost look like candy. Watch it out.
And just so that you know, the pills are just Tylenol and ibuprofen. It's not very exciting.
No, that's good. I'm glad
So-
we're close.
So we'll walk through them, and then I do know that we will not in any way finish these two today. There's no, I don't think there's any possibility that we'll come to a resolution today on either of these. So then next time we take them up, which will be next week, and Gail and I have done some planning, and hopefully we'll take them up next Wednesday after the floor to give people some time to come in and testify, whoever needs to come in. Does that make sense? Okay, but now we'll do a walkthrough and figure out what the issues are and what we might need to do if there's anything we need to address. So with that, I think Tucker, if you would like to join us, and I think we had on the agenda 708 first.
Yes.
Okay.
Do you mind if I eat my sandwich?
No, I think that, but you have to have your mask on. We've been told we always have to have our masks on in committee, so no, I was just being. Okay.
The
So-
bills are,
They're right on your desk, 708 and 448. Okay, so Tucker, would you like to walk us through this? Both of them appear pretty short, but I think aren't as straightforward as they might seem.
Good afternoon, Tucker Anderson, Office of Legislative Counsel. Would you like to start with H708?
Yes, please, thank you.
H708 is a committee bill that came out of the House Government Operations Committee. As background for both of the Burlington Charter amendments that you'll take a look at this afternoon, both of these were components of H448 as it was introduced. H448 as introduced contained the charter amendments that were passed in March of 2021 by the City of Burlington. There were 4 components: the adjustments to the Airport Commission, which you saw earlier this session, the Just Cause Eviction Ordinance Authority, which is contained in H708, the Thermal Energy System and Impact Fee Ordinance Authority, which is contained in H448. And the final piece was a ranked choice voting provision, which has not yet passed out of the House Government Operations Committee. Taking a look at H708, which contains the Just Cause Eviction Authority. This adds a new subdivision to Section 48 of the city's charter, which contains the enumerated regulatory powers of the city council that can be expressed through an ordinance. The new subdivision provides that the city council may adopt an ordinance concerning protections for residential tenants as defined in 9 VSA chapter 137 from eviction without just cause, where just cause shall include. And we're going to work through these. One of the things that I will note moving through here is that cross reference to 9 VSA chapter 137, that is the chapter that deals with residential tenancies. And there are exclusions from the general law definition of what constitutes a residential tenancy in that chapter. So there's already notable exclusions within this. Just cause under the terms of this ordinance authority shall include the following bases: a tenant's material breach of a written rental agreement, a tenant's violation of state law regulating tenant obligations and residential rental agreements, non-payment of rent, the tenant's failure to accept good faith renewal terms, substantial damage to the property by the tenant, members of the tenant's household, or guests, behavior of the tenant, members of the tenant's household or guests that adversely affects the health and safety of other tenants, the landlord or the landlord's representative. Finally, criminal activity on the premises of the rental property or any criminal threat against the landlord or the landlord's representative. Those last three, Romanets 5 through 7, were additions made by the House Government Operations Committee.
Let me just make sure I understand that. So what was passed by the city of Burlington voters was A66A up until Romanet 5 or through Romanet 4. And then the House Government Operations added 5, 6, and 7.
Right, the bases, substantial damage to the property by the tenant, the behavior of the tenant that adversely affects the health and safety of other tenants on the property, and criminal activity on the premises or any criminal threat against the landlord or the landlord's representative.
Okay, thank you.
Subdivision B.
Yes.
So Tucker, how did, now I know I can't get all the voters to respond to how they feel about those 3 additions, but how did the Burlington representatives and or?
I think that
Okay.
isn't a question
Okay.
for Tucker. I think
Okay.
that's a question for, that's not a drafting question.
Not that, okay,
That's a policy question.
yep, sorry.
Yes.
Thank you, Madam Chair. I think mine is a question on the drafting. I'm trying to understand what's going on. It says protection for residential tenants from eviction without just cause. So does this mean if I don't pay the rent, I can't get kicked out? Or does it mean the opposite of that?
It means the opposite.
Okay, thank you.
So each one of the Romanets that we just went through constitutes just cause for
Okay,
an eviction.
I was looking at it 180 degrees the other way.
The landlord tenant law, and then I will say the factual reality of how these procedures carry out are very nuanced and complicated. And there was robust testimony from many, many different experts in this area about how these procedures play out and how each of the parties is impacted based on, in particular, court proceedings and what each party can produce to actually carry out an eviction. So these are the starting bases that a landlord can point to and say, this is a just cause for me to begin the eviction process.
Okay, thank you.
The ordinance shall exclude from just cause. We get into some of the exclusions here. The expiration of a rental agreement as the sole grounds for termination of tenancy. So just because the lease has expired, that is not a basis for the just cause eviction. In addition to the exemptions that exist in general law for residential tenancies, the ordinance shall exempt from just cause, the just cause ordinance, subject to mitigation provisions. an important term as we move on. Sublets and in-unit rentals, as well as the following properties. Owner-occupied duplexes and triplexes, not included here. Those being withdrawn from the rental market, including properties to be occupied by the owner or an immediate family member as a primary residence, or properties being sold for owner-occupied use. So there's a lot packed into Romanet 2 there. But the properties that are exempted from the ordinance, those being withdrawn from the rental market, including those that the owner or a family member are going to move into, and properties that are going to be sold to another party who's going to use the property for their own occupancy.
So that wouldn't cover somebody that's selling the property, but to another land, if it's not for owner occupied
Correct.
purpose. Okay.
Romanet 3, those in need of substantial renovations that preclude occupancy. In subdivision capital C, we have some required inclusions for the ordinance. The ordinance must include provisions that first mitigate potential negative impacts on tenants and property owners, including requirements for adequate notice and reasonable relocation expenses. And we have a qualifying clause here. Reasonable relocation expenses that shall not exceed the value of 1 month's rent or another amount negotiated by the landlord and the tenant.
Can I go back 1 second and ask a question? It says the ordinance shall include, but I haven't seen any place where it talks about an ordinance of this. This means that they're giving the city council the right to establish an ordinance that does these things, but the ordinance has to include this. Okay, got
That
it.
is correct, and the subdivision 66 does start by saying.
Oh, right.
To provide by
ordinance.
Sorry about that. Yep,
And these are all regulatory
Yeah.
powers that would be expressed through
Okay.
ordinance. Anyway.
thank you. Sorry about that.
So the clause that we just worked through, the limitation on the reasonable relocation expenses, that clause was also added by House Government Operations
Sorry, which one?
in
Romanet 1,
Romanet
under subdivision C.
1. It's reasonable relocation expenses that shall not exceed the value of 1 month's rent or another amount that is negotiated by the landlord.
So that means if I want to kick somebody out, for lack of a better way of putting it, I'm a landlord and I want them to leave, I may have to pay them to move.
If what you're doing is subject to mitigation
Right.
provisions. And if we go back,
Yeah.
On ours, it's page 3, line 2.
yes, so if there are mitigation provisions that need to come into play for moving someone out of the apartment, an example I think that was discussed in House GovOps was those instances where you have substantial renovations that are going to be taking place and you are giving the tenant the boot either temporarily or permanently so that you can work on the property. That might be an instance that requires mitigation provisions, for example, relocation expenses. And a necessary pause in this entire subject area is that ultimately what the city adopts in its ordinances will be baked into all of the leases that the landlords are using moving
Right.
forward. So that's that provision or another amount negotiated by the landlord and the tenant. There's a cap on relocation expenses, but the lease will ultimately, in all likelihood, if the parties are, they should do, it will be in the lease that there will be X amount of relocation expenses portioned in these particular contexts. Romanet 2, the ordinance shall include provisions that provide for a 1-year probational period after the initial occupancy.
What is that?
A probational period in this context is that none of the just cause eviction standards established in the ordinance will apply during a 1-year period, because it's a trying out period essentially for the tenancy.
Meaning the ordinance doesn't take effect for a year.
The ordinance takes effect, but it won't be applied to a particular landlord-tenant relationship or a particular lease, right? Because there can be a 1-year probational period
So but that
for
means
the tenant.
during that 1 year, there is no just cause issue. I could kick somebody out.
Oh, so it's that, it's that each tenant gets 1 probation, 1 year before these provisions kick in.
Right, and this
So they're
is,
vulnerable.
this is more likely in this context. It's not a probational period that is given to the tenant. It's a probational period for the relationship that is more likely to favor the landlord and the property, right?
Right.
Because the tenant's protections here won't kick in until the probational period is over.
Got it. So they can't let them go. They could let them go for any reason before this.
Right, now this is where there was some, if we back up, one of the provisions we just talked about, if you go back to page 2, the ordinance excludes from just cause the expiration of a rental agreement as the sole grounds for the termination of the tenancy. And you have a 1-year probational period. So a landlord could craft a less than 1 year lease, right? That would be entirely covered by the probational period. And the fact that the lease expires is then a basis for the eviction of the tenant, because none of these will apply.
So
This gets
And
complicated.
whatever period of time we're talking about, I'm renting an apartment to Anthony. And I do 6-month lease. Because I did a 6-month lease, none of these are going to apply to his rights so I can kick him out anytime I want to, whenever I want to, for whatever reason, because he has a 6-month lease. Is that what you're saying?
I'm saying that nothing here will apply within 1 year, because that is the term of the probational period.
But I still didn't get that 1 year so my leases run from January to December. This is gonna take effect on passage. The city ordinance gets it set up in April. The 1-year probationary period is from April to April, but my leases are from January to December. So what does that mean for me as a landlord?
Set aside all the dates and all the ordinance stuff that you just brought up and think of it in this context. This states that there's a 1-year probational period after initial occupancy. So for 1 year following the date that the tenant moves in and takes occupancy of the particular unit, the probational period tolls from that day, right? So if you moved in to the particular unit on January 1st of 2022, your probationary period will run until January 1st of 2023. Within that year, based on the understanding of the probational period that was discussed in the other chamber, and the folks that provided their very excellent expert testimony on this, that means that the provisions for protection for just cause evictions will not apply within that 1 year period after initial occupancy. That's the probationary period.
And then you said something about 6 months. You brought that up. That's what confused us, I think.
Right. And this is because one of the items that is not just cause by definition is the expiration of the lease. And that's one of the tools, at least in the testimony that came up in the House, that landlords can often use to avoid a judicial process, is that if the lease is expired you no longer have a tenancy and you can be moved out of the unit. Well, if the lease is 6 months, you have 1 year from the date you take occupancy that you're in a probational period and none of the protections apply. Well, that means that the fact that your lease expires at the 6-month period means that you can be moved out of the unit.
All right, so not protected, right?
Because you're not
Phrase
protected.
that says like, can't be moved out because of.
So within that 1 year period, I'm still really
It's,
confused
it's
by
it's
it.
a little confusing, but I get it.
So if I rent an apartment in March, I have until March of the next year. And during that period of time, I have no protections because none of this applies. I can be booted out for any reason at all. Just as if I have a 3-month probationary period when I start my job, I can be booted out of that at any point. I have no protections during that probationary period in the job.
That's how I'm
Is that-
understanding it.
Is that what is being said?
Beyond whatever protections you already have under other law, right?
Yeah.
So.
But these
for these
particular.
specific provisions, yes. will
And
not
that
apply.
applies to every tenancy, regardless of when they start their tenancy. It has no relationship to when this becomes effective or when the city council, it's, that particular tenancy has a 1-year probationary period.
That's correct,
So his will be different than mine,
yes.
because he moved in March and I moved in May.
Yes.
Okay,
Why would any tenant do this? I mean, I wouldn't want to move in knowing he could throw me out the next day.
But that's what exists now all over the state. I mean, unfortunately, we have no cause in this state. That is a big issue
Now-
here in the state.
Your rights as a
But
tenant.
people do have rights after 28 days.
excuse me. Keisha, we can't see you. I don't know why.
In addition to any protections that exist in law or that might already exist, for example, in the city of Burlington, remember that you also have a contract between these parties, which is the lease.
Yeah.
That fixes rights as well. So really, this is dealing with the terms of the lease, and Burlington here in this particular subdivision is saying that as a component of that lease, under this just cause ordinance, that there can be a 1-year probationary period where the city's specific just cause provisions will not apply to the relationship between the landlord and
And
tenant.
begin on year 2.
Yes,
And can I ask if that was also added by HGO or if that was part of the original?
the provision for the probational period was not added by HDO, but, and I have to qualify this by saying that my memory is more fuzzy on this particular detail. I believe that the 1-year clause was added in House Gov Ops, but I will confirm, I'll go back and compare the bills introduced.
So there was a probationary period, but they added the 1 year, you think? Okay,
Yes, that's my recollection.
okay. All right, we'll check on that. Okay, thank you.
It's Romanet 3. Limit unreasonable rent increases to prevent de facto evictions or non-renewals, although this shall not be construed to limit rents beyond the purpose of preventing individual evictions. So the ordinance shall include provisions that limit unreasonable rent increases to prevent de facto evictions or non-renewals.
And was that part of the original?
Yes.
Okay.
Who decides what's unreasonable?
The city council when they adopt the ordinance.
Yeah, the ordinance will
That's
tell
the-
you in particular.
All right.
And then the qualifying clause is that the construction of that portion of the ordinance shall not be construed to limit rents beyond the purpose of preventing individual evictions. So this isn't about a cap or limit on the rent that can be set. It is a component of the ordinance that looks at the unreasonable increase in a particular rent that's applied to a tenant in order to accomplish an eviction.
Got it.
And finally, mitigate potential impacts on small landlords. And this last one is a provision that was added in HGO, and there were a few different versions of this that were put together, and ultimately, between the city and the members of the committee, it was determined that the term small landlords was appropriate here.
Do you know what they meant by small landlords?
One of the versions of this that they worked on looked at 4 units or less. But ultimately, when they looked at the availability of rental housing and the rental housing roster in Burlington, that covered a significant portion of the rental housing. And afterwards, I believe the discussion was just focus it on small landlords and leave it up to the city council to determine what the small landlord population is.
Landlords under 5 feet.
Okay, thank you for that. We needed a little.
The final piece here. The ordinance shall define what is reasonable and adequate notice in defining just cause, and shall require that landlords provide notice of just cause and other legal requirements as part of the rental agreement.
And that was part of the original.
Yes.
So it's just little Romanet 4 is not part of the original, added by HGO.
Yes.
Man,
This is instructing the city council to come up with an ordinance that includes or is limited by these various things.
Yes.
Doesn't necessarily say when it's encompassed by how long they have to do.
It's granting the legislative authority to adopt a just cause eviction ordinance with specific guidelines as to what just cause is, with specific exemptions from types of properties that are covered. And finally, with requirements for what must be included in the ordinance.
Okay.
So this, as,
Yes,
so this addresses a huge issue in Vermont, which we have all been reading about in the articles about the landlord vogue and many other landlords, particularly in this hot housing market. We are having a huge issue in the Upper Valley with a landlord who sold a bunch of apartments to an investor in Boston. And there is no cause in this state. You don't need to have a cause to kick people out. And we now have probably 30 families in the Upper Valley that have just been, they have like till the end of April, no reason, no nothing. Out they are. It's really challenging. And we have a less than 1% vacancy rate in the Upper Valley.
we
this-
do.
Yeah,
Most
and
of-
so
most
this
of
is
Vermont
kids
does.
out of schools, families out of our community. It's just
So-
addressing just cause is something we have had to do for a long time. I'm sort of sorry we're just doing it in Burlington because we need to do it statewide, but this will be an interesting.
So would that have been covered? Because I remember reading the article, and one of the things that was stated was that the buildings were in bad need of repair and that they really need to do major renovations. So this wouldn't have covered that anyway, because they are major renovations.
Yes, because if they were
No,
doing,
those in need of.
then they get this.
No,
They get help on a new apartment. If there are substantial renovations, this added language at the top of page 3, I believe, Tucker, correct me if I'm wrong, would mean that the rest, I think that was the second
if they
vote.
put it in the charter, I mean, if they put it in the ordinance, that,
Yes, right. So,
Well,
Mike,
it seems like you say substantial renovations are needed, is that somebody's opinion, you know what I mean? Maybe I'm saying that because
Right.
how do we know what substantial renovations are?
they might not all be.
Not saying you know the answer, saying that it raises
Yeah.
all those kinds of questions about interpreting what's really going on.
One of the things that came up with a lot of these same questions on the House side is that ultimately this gets tried through a judicial process if there's a conflict if there's a disagreement about the lease terms, if there's some sort of conflict about the need to perform the renovations, ultimately it's going to be a court that is going to review the lease, the relationship between the landlord and tenant, and whether there's a basis, for example, for a claim from the tenant that this is not a just cause eviction.
Just as an aside, the Bow Brothers said that they're gonna build a 42-unit complex here in Montpelier.
I thought that was turned down.
Oh, I saw it in the headline. I haven't read the story yet. This was in our local paper.
Yeah, it's still pending. It is still pending. So,
So, Mr. Chair,
yeah,
I think you're right about the second article that involved the Afghan refugees.
What?
That were being, there have been two big articles on the
no,
boat.
this one was the Upper Valley that I read.
Oh, this, the other, okay.
It was the one in the Upper Valley. So
Mm.
I do remember that one, but so I do know, and I know this is a really horrible problem that we have to
It is.
address. It is a horrible problem. I also know from a landlord's perspective that it's also a horrible problem. It takes 6 to 8 months to evict someone. And I know that.
And longer sometimes.
Because I work with a housing agency and they're in a specific position, but I attend landlord meetings in Brattleboro. And I do know that it, from a landlord's perspective, it also is very hard to evict. So I just, yeah, I don't know what.
Well, this adds, I have to say, the HGO language has added helpful more language for landlords. They've added damage to the apartment, behavior of the tenant, and criminal activity. So they've added some more
Yeah,
things for both sides.
right. Yeah, no, I see that. Yeah, Brian.
Thank you, Madam Chair.
Oh,
Yeah,
I'm
and
sorry.
I appreciate that you brought that up because I've also been contacted by not just one, but several landlords in my district. And this goes to Tucker's point too, that eventually have to resort to the judicial process to
Yeah,
get any satisfaction. And that is so clogged up that there's just no relief for them. And while I'm very sensitive to people that are unfairly targeted for eviction, and I am, I also understand the frustration of the landlord who has to continue to pay the bills with all the inherent electricity and insurance and everything else, and getting nothing back in terms of rent, and watching drug deals happen and the cops show up and nothing happened. It just goes on and on and on. And they're gonna take it to court, but the first available hearing is like in 2 years. So it's a balancing act here for sure.
and I do know one of my favorite landlords down there, who we don't always agree on things, has been in the position, and I know he represents many others, who needed to evict somebody, couldn't. It took over 6 months. No rent was being collected, and when they finally got the people evicted, there was about $10,000 worth of damage to the apartment.
Yeah.
And that, so he forewent, foregone 6 months of rent, and then, anyway, so it is a huge problem for both landlords and tenants, and we need to make sure that tenants aren't just being booted out, and that landlords aren't being, they're landlords and they're landlords, so.
Oh, and they're tenants and they're tenants. I mean, that's the challenge.
Yeah,
It's-
yeah.
Humans are such
Yeah.
a challenging crowd. to
Oh,
deal
if
with.
we only didn't have to deal with them,
I know. It's a very-
dogs would be much easier.
So what I also am just thinking of our friends at Vermont Legal Aid. If we could, over the next couple of years, fix just cause, we could deal with a ton of their cases, because I'll tell you, I think Vermont Legal Aid deals with just so many of these cases that I think if we could fix this, maybe we will reduce their caseload, which would be great.
Or increase it.
Or-
All right, so I think that what we'll do is we'll make sure that we get, this is the one that, I think, Tom, what's Tom's last name, Proctor, is it Tom?
Yes,
Okay, and
he's been
get him in here, and the city of Burlington,
in Vermont legal aid,
and, oh, okay, I didn't.
like Wendy Morgan, I think.
Wendy is, okay, and Erica Wolfing had somebody she wanted to come in, so we'll make sure we get them
I
in.
didn't get all
Oh,
those names, so
okay.
sorry, I was.
We'll get it, hold on,
Yeah.
I'll write it down for you, right?
No, it's okay, I'll,
She's
I
got
have a little piece of paper. someplace.
it.
Oh, all my little notepads are gone. Yes, okay. I just recycled this. Okay, so are there any more drafting kinds of questions, technical questions of, yeah,
I have a technical question, well, maybe this is a technical question. It's a policy question, what it got passed by. I'm gonna ask the Collmore question.
I was just looking it up.
What,
The 708 on third reading passed 98 to 49 in the House. And again, not reading into anyone's vote, and I hope I can just say this without any political repercussions. It
Okay.
looks like it fell along political.
sadly, it does. Frustrated if that's the case, but there we are.
I don't know how it came out of committee. I haven't looked at it.
so should we, is there any, who else? I have Erica, Tom, Proctor, Wendy, and the city of Burlington.
Blah, blah, blah. Maybe Keisha knows more than we do as the Chittenden rep. I mean, senator, I mean, you know.
Because I know
person-
Tom Proctor is the one that worked really
Right.
hard on.
Yes.
Yeah. I mean, Counselor Zariah Hightower might
Keisha,
be in, yeah. Can you hear
Keisha,
me?
you are not on this screen because you must have your screen set, your videos turned off, so.
Oh, there you are.
Okay, hi. I mean, if you're looking for someone else kind of helping to advance it from the city side, Counselor Zariah Hightower worked on it. I think Tom Proctor is your best bet on some of the details from a positive perspective, but Counselor Hightower is also helpful. And then you're probably just looking at, you know, other city officials. I think reaching out to the mayor's office and seeing who makes sense is the best. But yeah, that's all I would have to offer at this stage.
Okay, thanks. Yeah, probably Dan Richardson, who's the city attorney. Okay, great, thanks.
If you look at the HGO page, they had a pretty comprehensive list of witnesses, both from the city, from landlord associations, and from rental housing advocates.
Right.
And
Of course they have.
Dan Richardson, Counselor Carpenter from the city also was at almost every
You
meeting.
mean Sarah? She's a city councilor.
Yes.
Yeah, Sarah Carpenter, of course, as the city councilor and as a
Oh, she
housing.
would- Our very own housing Sarah Carpenter?
Yeah,
I didn't know she was-
BHFA, Sarah
Yeah, I
Carpenter.
didn't know she was.
In fact, she'd be a fabulous witness because she is both the housing queen and she's the city councilor.
All right, so we'll take that back up again.
That's
Okay,
gonna be a big one.
all right, so
We have another.
we have another one here. This is only one paragraph, but, okay. So just out of curiosity, why do we think that, they felt the need to put, the ability for the council to come up with an ordinance in the charter? I'm just curious, was it because the city council could not agree that they should develop an ordinance, or do you have any idea? I mean, they could develop an ordinance, they don't need the ability to develop an ordinance in their charter, right? They develop ordinances all the time.
So they only have the authority to enact an ordinance, to adopt an ordinance that is either in the general law or that is granted to them specifically.
Okay, all right,
So, and the reason they styled this in a way where they called out that it's an ordinance, I can't say, but it is embedded within the enumerated regulatory authorities of the city council.
okay, great, that answers my question, thank you.
And they may have been saying by ordinance so that they didn't have to say by rule, even though there's no procedural distinction between ordinance and rule.
Okay, great, thank you. Yeah, I think you versed us on that well.
That was November, yes.
Yes.
And I'm just curious, does that mean, let's say they do the ordinance, they write the ordinance, then it has to be approved by the city council, but do the voters get to public hearings or something? There's a
So
lot of hurdles this thing could go through before it actually becomes law.
I'll respond with the general law procedures and then note that the city of Burlington has a very comprehensive charter and they also have a mayoral system that it is not found generally within the general law, but typically ordinance is adopted by the city council at a meeting. Then there is a delayed 60 days before it takes effect. And in the interim, the citizens have the opportunity to petition based on 5% of the voters signing the petition for rescission of the ordinance as it has been adopted. There then has to be either a special meeting to vote on whether the ordinance will be rescinded, or it has to be warned for the annual meeting, provided that it falls within a 60-day period after the petition was filed. And during that pendency, the ordinance does not go into effect. There may be slightly different timelines in the city. I'll note that, not having my laptop open in front of me to look up the city charter. And there may also be involvement from the mayor, which is something that I'm not familiar with.
Okay, thank you. All right, jumping to H 448.
H 448, this was the underlying bill. Each of the provisions has been broken out so that all that is left in H 448 is the thermal energy system provision. Again, this is authority for the city council in Burlington to adopt an ordinance. Here, the ordinance would regulate thermal energy systems in residential and commercial buildings. Included within this authority is the authority to assess carbon impact or alternative compliance payments for the purpose of reducing greenhouse gas emissions throughout the city. So that's the authority. Moving on from that, no assessment of carbon impact or alternative compliance payment shall be imposed unless previously authorized by a majority of the legal voters of the city, voting on the question at an annual or special city meeting duly warned for that purpose. So you have three components here within this brief subdivision. First, the authority to regulate thermal energy systems in residential and commercial buildings. Second, within that authority, the specific call out for the opportunity to assess carbon impact or alternative compliance payments. And finally, a procedure here that before any carbon impact or alternative compliance payment is imposed, that it be approved by the voters of the city.
Okay, I have a couple questions. Thermal energy systems means heating. That's what it means, okay. So they will be able to, is this on existing units or is it on new units only? So if I have a fuel furnace, I mean, I have a regular traditional fuel furnace. So they could regulate that, tell me I can't have it anymore, or assess a fee on me because of the carbon impact if there's an approval by the town. Is that what this is saying? I have to admit that I'm that what this is saying?
We will work through this piece by piece, and I will give the upfront caveat that I am looking at the language of the delegation, and that you may hear more from the city about their intent and their plans that could be different from what you're delegating here. The delegated authority, to answer your first question, covers all residential and commercial buildings. There is nothing within this language that qualifies that it is existing or new. It is regulating thermal energy systems in residential and commercial buildings, full stop. As for the regulatory authority and when it might be applied, there's no limitation within this delegated authority saying that this can only be implemented, for example, when a change is occurring within a building or when it's a new building under construction. This is the broad delegation to regulate thermal energy systems in these buildings. It's made even potentially more broad through the call out of the opportunity to apply the impact or alternative compliance payments within the system of regulation of the thermal energy systems.
Thank you, Madam Chair. So if I own a home and I don't have the type of windows or insulation that someone might feel is necessary, and I'm running my heating, and I heat by oil, let's say, and I'm just running it. And I'm in some violation of the, I'm trying to think. Does everybody in Burlington decide whether I'm going to make this payment or not?
Under the scheme, first the ordinance would be proposed with the alternative compliance or impact fee. Then the entire city, yes, would determine whether the fee is going to be implemented in the city. If the entire city voters, well, not the entire, but the majority of the city voters say, yes, this is a fee we're going to apply for alternative compliance, then it would be applied to, yes, the homeowner, property owner, whomever that has the out of compliance thermal energy system.
But they don't vote on Senator Collomore's in particular.
Individuals.
Correct. It is the broad application of this system of payments.
And the payments could be set up in any way that the city council, in other words, it could be a one-time payment, it could be a monthly payment, it could be every year, it could be forever.
Yes, and each of those examples was discussed both in House GovOps and House Ways and Means. The question was, is this a one-time fee? Is it ongoing? Is it going to be based on an estimate based on the type of, in your example, oil burning furnace and the potential volume of CO2 it produces? And the answer was that that would be worked out through the ordinance adoption process.
And my final question is, where does the money go? Is that up to the city council to determine? It says to reduce greenhouse gas emissions throughout the city. How is that accomplished?
I believe there was testimony on the subject, but I can't
Okay.
recall
All right.
where they are planning to put the money.
Is this the language as it was passed by the voters?
Yes, it is.
Just to anticipate Senator Clarkson's question. 96-47 is what the vote was in the House.
In the House. Pretty similar to the other one.
Yep, and pretty similar demarcation line.
Yeah.
Well,
Yep. And what was the vote in Burlington? Do you recall if it was fairly like 2-1 or was it close?
For each of these proposals, it was about 2/3 in favor, somewhere in the 66 to 68% range for each of the charter.
So significantly supported.
So we would, the city council would figure out the ordinance about whether they were gonna do new or old, everybody, anybody with an apartment over, 2 apartments, not single family, or only single family, or only commercial, or they're gonna figure out that, then they're gonna figure out what the impact fee might be. And present it as an ordinance, and then the city will vote on whether they'll vote on both the full ordinance and, no, they don't vote on the ordinance.
They do not vote on the ordinance.
No, then they can appeal the ordinance, I'm sorry,
Yes.
I didn't mean that, yeah,
And then they can vote on the fee.
on the fee.
And there was testimony in the House from Darren Springer, who I believe is the head of Burlington Electric. And there was actually quite a bit of testimony from Darren Springer, and part of it was about the potential for grandfathering provisions that you just brought up, whether or not it's existing residential buildings will be captured by the ordinance. At what point during the change in a system would the city apply the requirements or potential fees? So there's, should be some documents. You can-
And one more question then, Senator Clarkson. Thermal energy systems includes, I hadn't even thought about it until Senator Collmore talked about windows. It includes everything that has to do with your heating, right? It isn't just my furnace, it's my windows, my insulation, my drafty back door.
Well, I don't think so. I think a system is a furnace, a heat pump, a system. It's not, windows are not part of a system, I don't believe.
I don't know how
They're
that's,
part of a complete
Well-
package of weatherizing your house, there's no
I
question.
don't know how that's defined here, it just,
I'll take a look at what the context might be. For the purposes of understanding what the delegation
Yeah.
is, what is a thermal energy system?
yeah,
I'll try to get you a square answer of what that might be. Within the context here, there was distinction in the previous testimony that happened in the House between, for example, what the system being regulated is, which was mostly around the heating system specifically, and then the more holistic idea of how you would evaluate the effectiveness of a particular system for a building, which might include, in that context, how much energy is going to be used by this heating system because the window or the thermal envelope of the building is not as tight as it could be.
Thermal envelope is not a system, I believe. So that, which
but we
leads,
could have a really, really tight house with a fuel furnace that is adding having
Yes.
less carbon impact than on a drafty house with a
Heat
heat
pump.
pump.
every,
So, it's-
I
yeah.
think it's, we all have to be clear, there is no heating system that does not have carbon input.
No, I didn't
Yeah.
mean none,
So-
I said less.
May I ask a question?
Yeah.
So was the cost of this for a time frame established, or I guess the ordinance would identify a time frame? Because obviously this isn't something they can just do tomorrow, given the age of our homes and the cost of the systems. Is that right? There was no time frame, but was there a cost discussed and how the cost to the
Okay.
how the cost to the residents was going to be handled? Was there gonna, did they talk about, I mean, this is a huge cost for most residents, which is sadly why most of it hasn't happened.
There was a lot of documentation and evidence submitted, particularly by Burlington Electric, around the research and studies they had done ahead of time around both the number of end users in the city that you can take a look at. And I am not familiar with this, but I will just note it for the committee that it was mentioned several times that this is a component of the city's net zero energy plan, which is perhaps more comprehensive and would describe some of the plans for this particular type of.
And we have, and
Yes,
I bet Carol has a lot of answers to this.
so we've been joined by Representative Ode and so Carol, you've heard some of our questions and comments, and we will be taking more testimony on this, but I don't know if you've heard the questions that we've been wrestling with. I mean,
I'm sorry, I have not,
Thank you,
and I did leave my huge amount of notes at home on this, I think. So I might have to come back to answer questions, looking to see if I have them here.
No, we recognize that, but maybe just some of the questions were, what would the city council be looking at? Like, what does thermal heating system or thermal energy system mean? Will it apply to new and old, or just new and residential? And when would it be applied? And time frame and all of that. And I don't know if at the city council level or at the organizing level to get this passed, there was discussion about any of those issues, or if you're just gonna leave it up to the city council to figure it out.
Well, there was testimony, but I can't recall what all of it was. But it is, the city council will look at it, and then I do know this, is that nothing can be imposed without a vote at a duly warned special or city election meeting, excuse me. And a majority of the legal voters have to say yes to it.
I think that applies only to the fee, not to the regulation. It says they can regulate the system, but they can't impose a fee without a vote, but they could regulate the system somehow. And so, do I
Okay.
understand that right, Tucker?
Yes.
Okay. And I don't know how you would regulate it without imposing a fee, but maybe refusing to give a certificate of occupancy.
Through
If
the
it
city's
didn't-
codes, like
Right.
is where they would use that enforcement authority.
Right. So you could enforce it in other ways besides a fee. So, I guess, Carol, who would you suggest we have come in? Darren Springer and from Berlin,
Yes,
Patrick, who
Darren
else?
Springer.
The mayor's
Um,
office?
Well, who we heard from was Darren Springer and also legislative counsel. And I have to think about who that was.
Probably Tucker. He's here.
Okay,
We're
Tucker,
just
was it
checking,
you?
right? Um,
but not more.
Just a second.
We should hear from the mayor's office, I guess. And was there a particular advocacy group that was working on this, like with the Just Cause one, there was Rights and Democracy was really involved with it. Was there a particular group, advocacy group that worked on this, do you know?
I guess there are many. Carol would know.
You're muted, Carol, if you're.
Sorry, I didn't hear that last question.
I just wondered if there was a particular advocacy group that worked on the passage of this, like with the Just Cause one. We know that Rights and Democracy was very active in that, in working on that, but wondered if there was some advocacy group that was active in getting this passed that we should hear from.
Well, if there was, we just didn't hear it in our committee, and it would have been in some of the papers that were,
Okay.
some of the things that were submitted.
All right, okay. So,
If you really want to look into that, you can ask Brian Chino. Brian Chino was the sponsor of it.
Right.
He might know who they.
And also, everybody from Efficiency Vermont to every environmental group, my guess is, this is a huge piece of their net zero.
right, but I want to know if there was somebody that was working on the passage of this that could help explain some of this. We understand that it's probably a good thing to do and a good direction to go, and all the environmental groups would support it, but
Brian is the man for our witnesses, is my guess.
to go to him for the, okay, we'll ask Brian, Gina. Okay. All right, any other questions, committee, or?
I'll just ask Carol.
Yeah.
What was, Carol, you did this, you represent reported this on the floor, right?
For ways
I
and-
only reported the House Ways and Means vote of
Oh, okay.
641 about about what would happen to assess a carbon impact or alternative compliance payment. That's it. That's the only thing I reported.
Got it. Okay, great.
Yeah.
Thanks.
Okay.
Glad to see you in Ways and Meanies.
Thank you so much. Glad to see all of you in the State House.
Yes.
Yes.
So nice.
All right.
Thanks.
committee. Thank you, Carol. Okay, well, that took a little less time than I had thought. Are there any other questions? Comments?
Not really.
So here's your choice, committee.
Oh, we have options.
We have options.
Options.
here.
Oh, we also could have a Godiva break.
We could have a good diet for break. We could then,
Well, mine, we could take our masks off for a minute.
are we offline? Yeah, we're gonna just take a 15-minute break here, 10-minute break to go do our essential things. I don't know how else to put that.
See people about horses.
See people about horses. And